everyone. Welcome to our webinar, which is the first segment of our webinar series, Whistleblowing, What to Do in 2022. This subject is both urgent and essential for two major reasons. First, the EU directive on the protection of persons who report breaches of union law was very recently approved in 2019. And second, and most important, this directive has already been transposed into Portuguese law last December. The relevance of the topic also comes from 5 basic reasons. First, the large number of companies compelled to set up internal reporting channels, as all private and public companies with more than 50 employees are covered by this obligation. Second, the very broad concept of protected whistleblowers has anyone with a functional relation with the organization, including former employees, self-employees, board members, trainees, volunteers, etc. Third, the deadline for having these channels perfectly operational, mid-June of this year, is already very, very close. Four, the reports may concern a very large number of matters here listed, and that go from privacy to consumer, production safety, public health, or financial interests. As the possible object of these reports is extremely wide, the new obligation can indeed affect numerous entities and businesses. And last, the complexity and the many questions arising from the new legal regime. Therefore, our main goal today is to help you understanding the implications of the recently approved legislation in 3 different fields: labor, privacy, and technology. So firstly, Margarida Costa Gomes will inform us on the main obligations for employers when implementing a reporting channel. Then Rita Paínho will share her views on how to assure proper privacy protection within the reporting channels. And last but not the least, Jan Tadeusz Stapper from Whistleblowing will present a technological useful solution for all of us. As such, and without further ado, I leave you with Margarida and the labor perspective on this matter.
Good morning, everyone. Today I'm going to talk about the legal requirements to set an internal channel within your company. According to the directive and the Portuguese law, the authority or entity must ensure that there are minimum requirements to be complied with. And don't make any mistakes, because major spoiler alert, there will be fines. This channel must ensure that the confidentiality of the reporting person's identity is kept. It must preserve the integrity of the report, and it must ensure that there are no unauthorized accesses. Moreover, a confirmation of receipt of the report should be given within 7 days. An impartial and competent person of department should be appointed to carry out the necessary investigation and to do the follow-up on the report. This careful follow-up must be carried within a short time frame. There is a time limit to provide of 3 months to provide feedback on the investigation to the reporting person. This is particularly important since if we fail to provide the reporting person with this feedback, then they will be allowed to report the breach externally. And to that end, the reporting channel must also contain clear and accessible information on the procedures for making reports externally to competent authorities. It is essential that such information is clear and thorough, and to the extent possible, it should be accessible to persons other than the employees. For instance, business partners, suppliers, providers, any person or entity actually who comes in contact with the entity through their work-related activities. During the implementation, the transposition period, there were several questions and issues that were raised to the Commission's expert group on the Whistleblowing Directive by member states and even by large corporations and employers associations. And we are now talking about these frequently asked questions who can help us to understand not only the purposes of the Commission when this directive was created, but also what pitfalls you must avoid when establishing your internal channel. And one of the most frequently asked questions was, may groups of companies share a central reporting channel? The answer from the expert group was a clear no. And this has to do, on the one hand, for reasons linked to the purpose of the directive, which is to have the most possible reports numbers. And there were studies that showed that usually whistleblowers feel more comfortable reporting to the companies they have a relationship with. But there are also legal reasons that could impede this. And one of them is that the reporting channel, as explained before, must, for instance, contain the information on how to report externally and which external channels are available. Since this vary widely from member state to member state, there would no way that this could be made through a shared centralized channel. Moreover, as Rita explained before, the member states have a high leeway on which matters, which subjects can be afforded the protection of the whistleblowing directive. But those also may vary from member state to member state, and that would imply that one report could have a different treatment in a different member state. Finally, because the whistleblower may request one-on-one and in-person meetings with the company they have the employment relationship with, or the work-related relationship with, those central channels would not be a viable option. Another question that was made following this one and the no answer from the expert group was, if this is so, should the parent companies remain open to receiving reports from the affiliates or subsidiaries? Again, the expert group gave a very clear answer. Yes, they should be open to receiving those reports, and if those happen, the parent company should accept and follow up on the report. So that would mean that the parent company should also be bound to give the reporting person the of receipt within 7 days. They should also give them a follow-up within 3 months. They should revert to them and ask more information if needed, or liaise with them with any questions that they may pose. Another question is, well, if we have to set an internal channel, each entity at a local level, what happens when a report broaches subjects that affect more companies, more entities of the group company? In this case, the reporting person must ask the whistleblowers for their consent to report the facts to the company that is more able to address the breach that was reported. However, since the whistleblower may reject this, they must be given the opportunity to withdraw the initial report and to report externally. There are, however, some flexibility in what regards the operation of the internal channels. So, to the question of whether it is possible to outsource the operation of internal channels to parent companies, there is a mixed answer which says that companies may share resources concerning the receipt of the reports. This applies not only to group companies, but also to entities which may have no link whatsoever, but decide to share these resources. But in this case, the responsibility to maintain the confidentiality, to provide feedback, and to address the reported breach remains always with each individual company, not the parent company, not the company of the same group, not the company with whom we are sharing the resources regarding the receipt of the reports. It is possible for a medium-sized subsidiary or affiliate to benefit from the investigative capacity of the parent company. But once again, the whistleblower may request that all the investigation should be dealt with internally at a local level entity. So while you must be prepared, while you can to a certain extent share resources, in the end, everything will remain on the hands of the whistleblower. They will be the people with the discretion to decide whether a report can be addressed internally, whether the investigation should be carried out internal, whether there will be no reports of the breach to other entities of the group of companies. When we were talking about the following up of the reporting, there are really stringent requirements for the person who must do the follow-up of those reports. This person must be impartial and competent, but in medium-sized companies or smaller-sized companies, there is nothing to prevent that this function may be dual, a dual function held by a company officer, for instance, a compliance officer, a human resources officer, who has a direct channel to the organization head. We must understand that the whistleblowing directive was made to allow breaches of EU law to become known and to be widely addressed. So all these requirements, all these facilities that are given to the reporting person are meant to ensure that it is very easy to report, and that people would not lose control of the reporting after they issued one. So this is also in the interest of the companies, since it has been those same studies which showed that whistleblowers are more comfortable reporting internally, also showed that if the whistleblowers were sure that there would be adequate follow-up and that those reports would be taken seriously investigated, they would be less inclined to report externally or to go public, which is another option afforded to them. So it is in the utmost interest of the company to get this right from the beginning. Another question that was made to the expert group is if it would be possible to outsource the operation of internal channels to external entities, which may seem like a conundrum, but again, there is a nuance. The operation of reporting channels may be transferred to third parties, external platform providers, for instance, as you will learn on the final presentation of this webinar, external counsels, auditors, etc. But again, not companies of the same group of companies. That is forbidden. But this, and this is explained because these third parties won't give a follow-up. They will only receive the reports of breaches on the behalf of the obliged entity. The reports can be done was also addressed by the expert group, and indeed the Portugal legislation received this understanding. The reports may be presented or in a written form or orally, and because they may be presented orally, there are no restrictions on video conferences, for instance, phone calls, hotlines, whatever, provided that the requirements of confidentiality, of safety are and of preservation of the preservation of the integrity of the report are ensured. As this is, communications of breach by email are also accepted. In Portugal, the law allows for the companies to establish that the reporting person can do so anonymously or not. So it is for the company to decide whether the report can be done anonymously or the person, the reporting person must identify themselves. However, bear in mind that you must at all times ensure the confidentiality of the identity of the reporting person. And the Commission also said that if an anonymous reporting person subsequently come to be identified, they should be afforded the protection of the directive. So, as announced at the beginning of my talk, there will be fines. And the consequences of not setting an adequate internal reporting channel is treated as an administrative offence, which can be either a very serious administrative offence or a serious administrative offence, depending on the requirements that are amiss at each moment, and with possible fines that vary between 10,000 euros and 250,000 euros, depending the type and the severity of the breach. What are the rights of employees concerning reports? Besides the rights of receiving feedback, of having their identity preserved, the employees or work-related whistleblowers have the right to be compensated in case of retaliation for reports. And with major impact on what is a Retaliation Act, there is a reverse of the burden of proof on the retaliation. That means that acts that directly or indirectly occur on a professional context after a reporting would be deemed retaliation unless the concerned entity can prove otherwise. This is very important to bear in mind. Moreover, the employees or the reporting persons may require that adequate measures be taken to prevent an act of retaliation. And those measures could be either internal, they must report those possible retaliations, or in their report they may ask for specific attention be given to this issue, or they can even go to courts to ask for protection measures. And regarding these judicial measures, they will also be afforded the necessary protection to witnesses in criminal procedures. So as you see, there are several requirements that must be complied with. This is a world, I am sure that lots of questions will still arise when we are implementing in practice all these requirements. But since I underlined that no effort must be saved to prevent the identity of the reporting person to be safeguarded, as well as to impede unauthorized access, I will leave the floor to my colleague, Rita Paínho, who will explain all you have to know about this. Thank you very much.
Hello, everyone. Good morning. I am Rita Paínho, as Margarida just said. And I think that we are trying now to see, well, privacy again. Why privacy? As Rita stated in the beginning of her presentation, we are going to check now for the privacy implications of the whistleblowing directive. And the first thought that you can consider is, why are we here speaking about privacy in whistleblowing considerations? Well, where does privacy step in? It steps in on moment zero because it's all about natural persons. If you look into the system of whistleblowing, you will understand that you have two dimensions, basically. You have whistleblower, which is a natural person by consideration, it can't be otherwise, and third parties, while they envisage persons of the denounced, which are natural persons too, or linked to natural persons at the end of the day. So when you have a whistleblowing system mounted up, and you will need one, as Margarida explained, because of Law 93/2021, you are stuck up with privacy. And the matter is that under Law 2021, there are legal requirements to comply with, and they are scattered all over the diploma, but you also have specific provision where it states on Article 19 that all the things that you do should be GDPR compliant. So welcome back to GDPR and to all the things that you already, probably most of you know if you are in compliance departments, but you will need to cross-check this and link this directly with whistleblowing procedure. So when you look into the new law, you see that essentially you have three articles that are very concerned for the privacy teams, and they are Article 18 for confidentiality, Article 19 specifically for GDPR compliance, and Article 20 for retention periods. And I mentioned these three essentially because, well, one, it's obvious, it's the GDPR compliance, and the other two because they bring up some more information concerning what you should and you should not do when you are on a whistleblowing system. But it's all linked to privacy and will have an impact on your system and how you create it. So we are going to start reversely. We are not going to start for Article 18, which should be the first one, but we are going to address this first from a GDPR compliant perspective. Article 19, as I said, from the law 23/2021 addresses that all the systems should be GDPR compliant. And this leads us and takes us back to GDPR. And when we look at GDPR, we have Article 5, which is the mother of all articles, and it states the basic principles that should be addressed in privacy of citizens and when you are processing data. So, as we are all now aware of, and I hope you are too, that GDPR is only applicable to natural persons. So if you are processing data of a company, the GDPR law and regulation does not apply. But however, if you are, as you are in the case of whistleblowing systems, as I said, you have two dimensions, the whistleblower and the third party envisaged. And in those cases, you are processing data of natural persons. So you need to look into the principles of this Article 5. When you look into Article 5, the main reason and his construction says that all the things and the data operations that you do with personal data from natural persons have to be lawful, fairness, and transparent. And this means that you should, it includes a series of duties that then are scattered also on the GDPR, but includes basically a notion that you can not just do whatever you want. You have limits and you can use only the data for what you request. You need to inform privacy, the citizens and the people always about what you're doing with their data, why are you handling them, for how long, etc. Then you have a purpose limitation, and this means that you should not use the data for any other purpose than what you have done for the collection. So in a whistleblowing system, you can only use data for the denounce. This is a little bit more effectively granted in the whistleblowing legislation, but the fact that it was also a natural consequence of GDPR. You can only use the data for the denounce itself and not other purposes. Then you have data minimization. It is also, and we will see this in a minute, in the whistleblowing directive and law, because you can only use the data that is strictly necessary for the purpose that you are using it. So if I am collecting data because there was a denounce on a whistleblowing system based on this law, I only need the data that are necessary for this whistleblowing denounce. So I cannot use other data that by chance a person, when he's relating the facts, just decides to tell me. I should erase them, and we'll see that in a minute. Then you have accuracy. Data should be accurate. This means that they should be updated in time. You cannot just access something, require the data, and then just leave them there forever in a term that they are not essentially modified or updated as necessary. Then you have the purpose of storage limitation. Actually, this is a retention limitation, and it's also specifically foreseen in the whistleblowing law, which is you have a limitation of timeline to use the data. You cannot use the data forever. One of the things that all people that work on privacy know, and they keep telling to their companies and their internal departments, is that no, you cannot keep data forever. You need to establish a timeline, establish the timeline in which the purpose is still grounded, and then you have to eliminate the data. And this is the storage limitation purpose. And then you have integrity and confidentiality, which basically also leads to security problems. And security problems mean that you need to have a very good system. As we know nowadays, each more time, all of this, it's not possible to manage this in a non-platform or in a non-centralized software system. You cannot have anymore those nice results within people's and manual and subscript. You need to have essentially a platform to manage your data requests, and the bigger the company is, or the higher the risk of whistleblowing denouncers due to the activity of the company, more you should invest on a platform like this. So, and finally, you have a principle that's very important for you companies, which is the principle of accountability. That is, in GDPR, you have natural persons on one side, which are the data subjects, and on the other side, you have the controller. And who is the controller? The controller is the company or the person, the entity. It doesn't need to be a company. Public entities are also veiled by GDPR. It's the entity that defines who is going to, why is going to treat that data, for how long, well, it will be kept, what security measures we will adopt, what information it will provide to the data subjects, etc. He's the controller, and the company being the controller, he's accountable for what it has done with the citizens' personal data. So accountability means, in basic words, those nice articles 83 and ahead of GDPR, which mention the fines, the lovely fines of 10 million or 2% of the total revenue of the group, or 20 million or 4% of the total revenue of the group. This is accountability. Accountability for damages, accountability for damages towards citizens, accountability for damages towards other companies, and accountability for damages and for fines based on the authorities in Portugal, as I think we all know, CNPD. So we need to understand that when we are speaking about this new law and whistleblowing system, you will need to have a whistleblowing, as Margarida just mentioned. So you will need to see if you are within the requirements, then, okay, I need to do this. And then when you look into and you say, I need to do this, you have to make a tick on the side and say, I need to do this GDPR compliant. So I need to go and check with the GDPR teams that I'm doing this well, and there is nothing missing, because all whistleblowing procedures that you are going to perform during the lifetime of this law, this new law, will be also abide by the GDPR principles under Article 5. All these are applicable to all data subjects in both dimensions. You cannot only think about the person that is making the denounce, you have to protect the person that is making the denounce and the person that is the envisaged person in the denounce. And you are accountable for it. So you are the company that needs to pay the bill at the end of the day if something goes wrong. So you are the controller. You are responsible for what you have mounted up, and that is perfectly performing, okay? So you need to do this. So under the GDPR, and when you look into it, I would like to stress out 3 things important for you at this point so that you can think and start working with your GDPR privacy teams at your company. So the first thing is that you look into GDPR compliance and confidentiality. And you say, okay, but whistleblower has a right to anonymity. And it also has a right to confidentiality. And if the whistleblower, and this is something that may cross your mind, if the whistleblower decides to opt by anonymity, then data is anonymous because it doesn't identify himself. So I don't need to have concerns about him. In my opinion, this is wrong, and it's a wrong approach of the problem. And why? Because, for instance, Law 93/2021 expressly foresees that one of the channels of denounce may be recording denounce on the telephone. So if you record the voice of a person, you have personal data involved, even if the person doesn't identify itself, like being, I am Ana Rita Paínho and I'm the citizen card holder number whatever. So this will bring you to a problem. You cannot have control over what is essentially anonymized and what is not. So you have to treat the whistleblower always as a data subject in no matter what condition. This is our advice to you, at least. And then you need to understand that when a person requires for anonymity, you have to think about anonymity in a different way. And the standard is they don't want to be identified. Against what? They don't want to be identified, and staff that it's working on my whistleblowing system has to know the minimum and should not be aware of these people's identity. And on the other side, I have to comply with the principles of GDPR. So this person, although it requested anonymity, still needs to be informed about the rights, etc., which we'll see in a second. And I need to be compliant. You need to see this, and you need to make this balance. And then there is the right to confidentiality. And this right applies to both dimensions. Okay, so on one side, you have the whistleblower that may or may not have asked for anonymity, but still is always subject to confidentiality. Its data and its denounce is confidential. And on the other side, and this is very, very important, you should have the prevention of the interest of the third parties that are object of the denounce. Because in a perfect world, denounces are true and they have a reasoning, but you cannot control that. You cannot control the persons that are making denounces. So at a certain moment, probably you will have a denounce that it has no grounds. And the third party envisage has to be protected. So you have to see this always in these two dimensions. And in the dimension of the third parties, you need to know that the staff that is handling the information is completely aware, has confidentiality agreements, and is completely aware that this information is extremely sensitive, one of the top essentially sensitive information of the company, and should not be revealed, leaked, commented, whatever, in any manner. So you need to also cover this side with the people of the team that will be handling this whistleblowing procedures. And then you have to protect this. And there comes again the technology and the platforms against the access by accident or by intrusion of any third party. So anything that is external to your organization, unless of course you are doing this already on the police channels or on the criminal denounce. But apart from that, you need to be sure that your system is contained and controlled, and this is extremely important. So, next slide, please. And when you come to this, you see that then you have some difficulties and practical difficulties, which is that, okay, we already saw we have two people here that both need protection, the whistleblower and the third party. They are all connected with GDPR. I need to have this mounted up to be GDPR proof, bulletproof too, and everything is okay. And one of the principles of GDPR is the right of information of data subjects. So, and you tell me, okay, but they are both data subjects. You are denouncing against Margarida, let's say, and Margarida is the third party. And of course, she will not have known of her denounce at the first moment. So how can I help? And how can I tell her the right of information that I'm collecting their data? Her data in this case. And this is a tricky. Most of you already have hotlines for other things. Essentially, if you are multinational companies, most of you have hotlines which were a bit shady under CNPD radar, but you have them. It's a fact. So our best advice is to keep this as it was in that sense, which is that you need to have the right of information prepared to be provided to any whistleblower on whatever channel they use to make the denounce. And you need to have an information package prepared to provide to the third party envisaged on the moment that you have the first contact with them concerning the denounce itself. So up until then, it is justified by the interest of the law and the protection of the whistleblower, but at to a certain moment you have to inform the data subject of its rights. So what we see here as an example of what you need to say when someone is making a whistleblowing denounce, to that data subject, which is basically, well, look, I'm going to collect your data and these are necessary because I have to comply with some legal obligations under law 93/2021, which is the law upon which you are making this denounce, that grounds your denounce. But apart from that, I also need to tell you that I am the controller entity. Why am I doing this? And what is the scope of this data collection? How can you, as the data subject, and this links a bit with what Margarida just told you about the times of you have a timeline to reply, you have a timeline to provide updates to the whistleblower, etc. So how will the whistleblower be up to date to the complaint? Essentially on their data, I mean, on the data that they have provided and that they are their data and not the company's data. So that they know that it is updated, how can they be ratified, and how can they be erased. Of course, that erasure of data in these circumstances, it's very difficult because you can only erase the data that are not necessary for the complaint. Actually, you should do that. But if the data are necessary for the complaint, you have to keep them and you have to explain to the data subject that erasure is not possible because now you are in a system and you have to comply with the ruling of law 93/2021, which makes for a retention period of 5 years in most cases. So, and then you have to tell them about the retention limits, which are here based. There are other information that, of course, you need to provide in case you adopt a platform system, for instance, that it's based outside the EA. It could be a little more tricky and complicated, but you need to provide information on transfers of data to third countries. You need to provide adequate controls and etc. So you need to tell this to your data subject on the moment they contact you. And this should be prior to collecting the data, which means that you have a series of different channels that you can use to perform the denounce. So you can use platforms as we speak, my preferred choice, as you have seen. So you have a privacy policy that you should mount and put before and prior. People saying, okay, I agree and I want to make this denounce at the end of the form that they will be doing. You have email denounces and, well, you should have a system. I would recommend for a dedicated channel of email with a dedicated automatic reply once a denounce is received. That includes already a privacy policy. Of course, you cannot say to the data subject on a prior moment to send that he sends the email because you don't know he's going to send it, but it's on the immediate first contact that you have with him, an instant message that already includes the privacy policy. Then you have recorded phone calls. Recorded phone calls are tricky because if you make a really long message, and we all have passed through that when you need to call someplace and they need to record your message for some reason and they didn't even answer the phone, you are already 5 minutes listening, that your data can go all over the world and back on. And this makes not very friendly to use. But you can do something different. I mean, if you have an instance messaging service, you can make a short message with a link, identification to a privacy in your website, specific for this case. Or if you have recording messages, if you have phone calls with attendants, then you can put them on a script, on a short script with more information on your privacy website. And what we need to be sure here, and what you need to see when you put up this system to work, is that this is your obligation as a controller, and this is one of the fails of Article 83, so the 20 million. So you need to be sure that you protect and you provide the right of information to the data subjects, because this is your obligation, one of your main obligations. And then you have essentially the data limitation and the retention periods. And here again, we go back again. You have Article 18 of the Law 93/2021, and it states that essentially you have limits to the collection of data and you have retention periods. And this is scattered a bit between Article 18 and Article 20. And what you need to understand here is that these are specificities concerning GDPR. Okay, so you need to have minimal access to data. And there is a disposition in this law that states that you need to have access and you need to delete everything that it's not necessary for the complaint. This brings a problem, which is reporting on recorded phone calls. I cannot cut the phone call in bits and try to sue it again to see if it makes sense. But the law, in my opinion, gives an explanation and gives a way out for that, because it states also that unless this is not possible to do essentially on phone calls. So if you have recorded messages systems, you are not mandated to eliminate parts of the call that you think that are not of concern for the denounce. One of the possibilities, if you want to be very strict and compliant, is to then transcribe the calls, record in paper only what's necessary, or in platform only what's necessary, and then delete the call itself, or try to truncate the call itself. But I don't think that's really the most efficient way. So if the denounce is made by a call, it should be kept, in my opinion, and it's also safeguarded by this provision with this little exception. And they should not be taken for longer than necessary. And this means what? It means that you have also a specific disposition, which is 5 years under the law 93/2021. So you need to have this in a system that it's organized to be able to reply to this. The problem here is that you think, okay, 5 years, nice, because usually they ask us for 1 year or something like that. And then you see that recordings and calls and denounces start to come, and they are recorded and they are archived in the platform or whatever, and then 5 years have passed and no one has erased anything and no one has made swipes or whatever. So I really don't recommend this to be a manufacturing process of the company. I really think that this should be organized because actually the essence of the information that is contained in these denounces is very damaging for the third parties envisaged. So we need to be very careful with it. So the controllers are responsible for adequation of tools to envisage the principles of GDPR and the provisions of Law 93/2021. So when you look into this, you need to understand that I'm not free of GDPR. I need to go pick it up and see what do I need to put in this system so it works. And the system works with, you need to have a system that includes ways of communicating of denounces, ways of protecting the citizens that are in both sides of the denounce, ways of erasing data when necessary, and information to the data subjects at the proper times with the proper elements. So then you need to ensure deletion of unnecessary data. We already have spoken about that. And you need to ensure deletion at the term of the claim or of a legal or by mandate of legal provision. And this is also very important, which take us to our final conclusions. And our final notes is, as I said, you need to have a specific internal procedure for this. Don't think that you can just adapt. Don't think that you can just use another hotline that you had. This has specificities. And it is really important that you have this well from moment zero. Otherwise, you may have complications. Let's not forget that CNPD, in previous ways of living with previous systems, had a deliberation from 29, which now shall be scrapped from Earth because it's about money laundering and etc. And this is including in whistleblowing. But in any event, they were opposing to anonymity. They were opposing to a series of collection of ways of data and etc. So they will be strictly conservative about this. They will have to apply the law, but they will look into it in a manner that it's quite conservative and quite in the defense of the data subjects on both ways, whistleblower and denounced. So you should inform always the whistleblowers and the third parties. You should be aware that safety, integrity of this information is at your first top priority. You should have scanning routines to swipe non-essential data whenever possible, and this is for all written information. And you should have routine swipes to accommodate legal mandatory timelines of retention of the data. And you should create really a different procedure from other hotline that you have, for instance, for harassment or equality of conditions. So you should have a specific methodology for this purpose. And to this, I leave you to Jan. I hope I have pronounced well his name, because he will have a solution that's a platform that I think it merits with what we have just said. Thank you so much.
Thank you so much. Indeed, Jan, I'm from the Netherlands, and I was kindly asked by Sérvulo to show you how all of those elements that you will have to put in place as a legal entity within the scope of the directive, of the transposition into Portuguese law, will have to put in place. And we are here to help you. Who is we? We is Navex. Maybe you can show the next sheet, please. Navex is the largest provider in the world of compliance solutions. And one of the solutions here is called Whistleblowing. Whistleblowing is a software solution, which is basically a online reporting system, a case management system, and a reporting channel. We think it's very easy to use. It's multilingual. You'll see some other characteristics mentioned on this sheet. And on the next sheet, you can see what for us is one of the most important things, the confidentiality and the GDPR compliance. As the previous experts already identified, confidentiality is key here. Why? A little bit about that law. First of all, why do we want to protect whistleblowers? Is this just another headache for all those poor organizations in Europe created by the European Union? Maybe yes, but it has some thinking behind it. Whistleblowers have proven to be the best source of information about wrongdoing worldwide. At the same time, whistleblowers are very often facing a very serious risk of retaliation. And the best remedy against retaliation is either not to blow the whistle, but we don't want that, because as a society we want to know about wrongdoing, we want to prevent wrongdoing or cure it. And other options are maintaining the whistleblowing is to guarantee confidentiality or anonymity. And confidentiality is of course a key element both in the directive and in the whistleblower, both in the GDPR and the whistleblower protection directive. So it's very important, if you consider professionalizing your whistleblowing channel, to go beyond a telephone number and an email address or maybe a physical Dropbox, to keep in mind that there are software solutions that facilitate everything and allow you to check all of the boxes that were identified by the previous speakers. So I will not go through all of these elements. These are the ones that are the most important as identified within the directive and the national transposition. The key thought is, if it's quite tough to live up to all of those minimum standards, if you're building your own reporting channel, setting up your own reporting structure, and we see that even the largest of organizations in the world that are fully equipped to build something internally, they still outsource it. And the same goes for very small organizations. Even if you are expecting to receive only 1 or 2 reports per year, it can be tricky to address those, to process those fully in line with the directive, with the national transposition and the GDPR. So what is important to keep in mind if you're considering a professional channel, keep in mind, this was already addressed in the previous sheets, keep in mind that there's a very broad range of potential whistleblowers under that directive. It's not just employees, it's much broader than that. And keep in mind the first and the third point, that it is the work-related context. And that is exactly why this definition of worker is much broader than you would expect. It's not just an employee, it's anyone in a work-related context. And that means that all of those people, as you see in the third balloon, if I may call it like that, all those reports, all those groups can report confidentially and even anonymously if they want. A little bit more about the elements of the directive, this is just a different visualization of the content already provided before, but personally I very much believe in repeating the message. You also, this presentation will be available to you after this webinar. It's very important to make sure that if you're processing any data, to do it in line with the GDPR and the directive, to make sure that you have the people in place who can do that for you, who have knowledge about the GDPR, about whistleblowing, very often, ideally, who know how to communicate with somebody who is in a vulnerable position to make sure that that person is protected, and at the same time you receive that valuable information. And as a bottom line, to have a channel that is not just there to check the box, but is really inviting to be used. Because what is the nightmare of each organization in Europe is to have a semi-available reporting channel, but to read the information about the wrongdoing in the morning newspaper, because at that point your reputation as a company is ruined. Whether it is malicious reporting or genuine reporting, you should want to keep everything internal. I say thank you for now regarding this presentation, and I will move on to an online demonstration of how such a tool can look like. And I will do that almost at rocket speed because I don't want to take too much of your time. We're a little bit past our schedule. I just wanted to show you how this could look in practice. So you're looking at my screen now, and you're seeing the website, one of the web pages of a big bank called Société Générale. It's a French bank active in many countries, and they have a page, like many of you, I imagine, which is about compliance. And they explain how they would like to do business, what their vision is, some words by the big boss of Société Générale, and finally the idea is, well, this is how we would like to act, but if we don't, you have a possibility to raise an alert with us. And that page is a third-party page. This is Whistle-Be. It's available in many languages, also in Portuguese, and it allows whistleblowers to read information about the information that the reports that Société Générale would like to receive. It's all in Portuguese. You see it has been fully personalized, and then I will not send Société Générale an actual report at this point. I will continue in my demo account. Imagine that we send a report and then we want to read it. So imagine this is the case management system that you have access to as an organization because you have a Whistle-Be license, and you have that report just coming in and you want to read it. And you see that here somebody reported that João did something naughty. He paid for the renovation of his summer house with money of the company. This is a typical example of a whistleblowing report. There's some smoke, but you don't see the fire yet. That's why it's very important to be able to engage in a dialogue with a whistleblower. So for example, I can have this report, in my case, translate because my Portuguese is a little bit rusty. If I'll be fluent, I'll directly be able to have a request for additional information, which I will send in English. So I'm sending this back to the whistleblower, and that's how we can establish a dialogue. So the whistleblower would see this request for more information, and that's hopefully how we can start a dialogue with the whistleblower. And the more information comes in, the more information we can add into this case management system. We can say, well, this is about fraud in Lisbon, and we can say that this is regarding Lisbon, that this is about fraud. And labeling this case means that I can also generate statistics. So if my board or some other entity would like to see, some other body would like to see how the whistleblowing channel is being used, I can generate these kind of statistics and visualize how the channel is being used. Obviously, all of those matters are fully GDPR compliant. So for example, you'll have here information how to archive cases, how to delete cases in line with the minimization principle. You can set various teams who should have access to a case and not to other cases. So you have user access levels. You can even have, if you're a group company, you can have a so-called group account, which separates each entity one from the other in line with the desires of the European Commission that each legal entity should have its own channel. And if you want, if you have an independent person who is able to access various of them, you can set that user role as well. So you can separate information depending on the needs of your organization. All of this is of course available through smartphones, tablets, because it's an online solution. The servers are located in the European Union, in Ireland and the Netherlands, so there is no transfer of data outside of the GDPR. And we are setting these channels up in a matter of days for our customers. This was very, very briefly, and I'm happy to do this more extensively. If you want one-on-one, please contact Sérvulo for more information. I hope that this was a solid example of how a reporting channel and whistleblowing channel can look like. I addressed some of the most important elements of the GDPR and the directive. You could see it as part of that channel. And for more information, as I said before, please contact Sérvulo. Thank you for the opportunity to show this, and happy to share more information if you need it.
Thank you, Jan, and thank you all for such enlightening presentations. Before ending, it's important to mention that this was only the first of 3 webinars devoted to whistleblowing. We hope to see you again on February 15th on the topic whistleblowing and the prevention of corruption in public and private organizations. And finally, we leave you with our contacts in case you would like to reach out to me or Rita. Once again, thank you for being with us this morning. Thank you very much.